And now back to the breaking news we brought you at the top of the hour. Jurors are deadlocked in the murder trial of a federal agent. Jurors spent more than a week poring over 20 days of testimony in the Christopher Deedy Murder Trial, and in the end, it was a hung jury. For more on what this case, what happens, and what happens next, we're joined now by attorney Howard Luke. And Howard, thanks for joining us.
My pleasure.
Were you surprised when you heard it was a hung jury?
Not at all. I think when the options for the jury were between murder and an acquittal, I think most experienced trial lawyers believe that there was a distinct possibility of a hung jury.
Now, a lot of people think that having that lesser charge is good for the prosecution, but I know there's been cases, you've had high-profile cases,
right, where
your clients have been found not guilty of something much less than murder. So it really plays a role on both sides. That's
true. You know, one can never tell. It depends on what the attorneys think they can do for the best interest of their clients. I would like to say that, you know, there are some differences of opinion, I'm sure, but I believe that both Brooke Hart and Jan Foot are extremely experienced lawyers and very successful in their careers, and both have practiced for over 30 years very successfully. So they knew what they were doing. Whether they were right or wrong is another issue. What happens next, though, now, as they both prepare for a retrial? Well, a retrial is not a given, Paula. There is a state case, Moriwaki, where the defense can move to have the case dismissed if, in fact, certain factors are met. For example, if all the evidence went in to this jury, if the prosecution cannot put in any other evidence that would be different from the latest trial, there's a possibility, and just a possibility, I think a very slim one, that the judge might dismiss the case. I don't think that's going to happen. I think there will be a retrial. Do you think if there is a retrial that they would offer lesser charges? That's the great question. The answer is this. The trial that just completed, that was just finished, had specific evidence that in the minds of the prosecution, the defense, and the judge did not warrant the giving of the manslaughter instruction. But the instruction only goes in after all the evidence is in. So if there's a second trial, it depends what evidence is in. If the evidence is completely the same as the first trial, maybe not. I tend to think that if it's retried, a judge would include the manslaughter instruction. But it all depends on what evidence comes out in the second trial. All right, we'll just have to wait and see. You have to wait and see, and then again, you know, it's going to be quite a while down the road, and I think the defense probably will file a number of motions to dismiss the charges. That's my educated guess. All right. Thank you so much for joining us, Attorney Howard Luke. If you'd like to see his full interview, just head over to the top video section of our website. That's KITV.com. Thank you.